Hello and welcome to the DGA Deal Unpacked, what attorneys need to know. I'm David Shraga, the Secretary of the Beverly Hills Bar Association's Entertainment Law Section, and your moderator today. Before we get started, we want to acknowledge the Entertainment Law Section sponsor, Lawyers Mutual Insurance Company, who makes these great programs possible. For decades now, Lawyers Mutual has been the only California-based company continuously providing lawyers here with professional liability insurance coverage. The experts who direct Lawyers Mutual are actually a group of seasoned and specialized lawyers. They offer competitive premiums for a range of practice areas, including entertainment, and they are very good folks we have come to know over here. You can find them at lawyersmutual.com. And now let's run through these introductions quickly and then hear from these experts. Dan Stone is a member at Kauf, Maguire and Margolis LLP. Dan, your practice covers entertainment, media, tech, sports, labor, and employment. You represent clients ranging from individual artists to Fortune 100 companies and disputes involving all forms of IP, rights of publicity and privacy, labor law, ERISA, and California's Talent Agencies Act. Before joining your firm, you served as the Assistant General Counsel at the DGA, advising on collective bargaining agreements and pension and health plans, and a topic that's going to be very germane to today, of course. Our next panelist is Ryan Wedell. Ryan, you're a senior associate in the entertainment, tech, and advertising practice groups at Shepherd Century City Office. Your practice focuses on transactional matters in TV, film, and new media. You have deep expertise in scripted development and production, independent film, finance, branded content, and Hollywood Guild regulations, of course. You began your career as production counsel on Yellowstone, and you're now a go-to production lawyer on a range of acclaimed projects. Speaking with you both before this seminar, it's really an embarrassment of riches in terms of the productions that you've worked on. Sounds like award season talking to the two of you. As for me, I'm a mediator at Signature Resolution, where I mediate cases across industries with expertise in today's area, entertainment, of course, along with complex business, employment, and IP litigation. I'm also an arbitrator with the AAA. I've been a litigator, studio executive, and BA in legal at Miramax and NBC. And I've been a neutral now overall for 20 years in my career. So let's get started. Gentlemen, for a brief introduction, for those of us who have been following us this spring and early summer, this is the third installment of a series we've been doing together. Dan, you got us started talking about the WGA agreement, what was agreed. Ryan, you jumped in and helped us with the SAG and AFTRA agreement. And we're now bringing you two together to have one last roundup on what's changed in the DGA agreement. Big picture wise, we've talked about how this has been a more collaborative cycle for the town this year with no strikes. Interestingly, the DGA went first last time as they historically are known to do. This year they changed it up, and in many ways, this deal, they are following the lead of the WGA and SAG in certain ways, but there are many very specific DGA fine points to be aware of as well, and this agreement is very much their own. In terms of the overall big picture, the DGA's president, Christopher Nolan, had a quote that I thought kind of paints a nice picture. He says, quote, "We entered this negotiation with three main priorities: secure our health plan, protect jobs, and ensure that our members remain secure as AI continues to impact our industry. We succeeded in these areas and gained in many others." So for today, that means we're going to be talking about the headlines to be aware of for practitioners, the specific AI-related points that were agreed to. And we're also going to get into some of the nitty-gritty concerning changes in terms of the production rules, credit, residuals, and other issues that folks want to know about for film and television. Guys, I think that covered it, but just wanted to say welcome and thank you so much for being here today.
Thanks for having us, Dave. Always a pleasure to see you.
Appreciate it, Dave.
Thanks, guys. Okay, so let's get into some of these headline issues. What are the top-level headlines here that cut across this new memorandum of agreement? I think we're talking about things like the term, wages, health and welfare. Dan, you want to get us started?
Yeah, so I'll start off, and of course, Ryan, who knows a ton about this subject matter, is welcome to jump in at any time. I think when people look back on this bargaining cycle, the headline is going to be that it's a 4-year agreement. For decades, collective bargaining agreements in the entertainment industry have been 3 years, which means that when you're in year 3, people are preparing for the next round of negotiations. We saw this sort of in a heightened state in the 2023 bargaining cycle, where people were preparing for potential strikes, and then SAG and the WGA actually struck, which sort of crippled the business for a period of time, and that was right on the heels of COVID. This DGA agreement followed the WGA and SAG agreements in being a 4-year agreement, which basically now gives an extra year of labor peace, for lack of a better term, allows the business some continuity. And I think when people look back, whether it's a year from now or 20 years from now, the change from 3 to 4 years is going to be sort of the, top of the masthead headline.
And perhaps less notable, but equally as important, are the wage increases. And so when you compare to 2023, these are the traditional and customary wage increases. You're looking at 2.5% in the first year and 3% for each of the final 3 years, which are the typical amounts that you would expect as compared to 2023, when it was more around 4 to 5% per year to account for inflation at the time. The one note here is that in that first year, it is just a 2.5% increase, and that is largely because there is an outsized increase in the health contribution rate in the first year of the DGA agreement. And Dan, why don't you tell us a little bit more about that?
Yeah, so if you're following along, right, and you see, okay, the contract has become longer and the wage increases are pretty much on par with what's standard for these agreements, sort of what are the unions getting back? And one of the primary advances, and there are a lot of them, and we're going to go through them, and that Nolan quote that you provided is apt. But a main one financially is changes to the health plan and really increased contributions to the health plan. So just generally taking a step back for people who aren't that familiar with this, health plan contributions go up in two ways. The first is there's a percentage contribution. So, a percentage of the total compensation over and above the compensation is contribute to the health plan. That's number one. But the second is these collective bargaining agreements have caps. So it's compensation up to a certain amount. In this agreement, again, following on the agreements that came before it, there's an increase, a substantial increase in both the contribution rate and some substantial increases in some of the caps. So I'll dig into the details, and then Ryan, I'm sure, will chime in and we can discuss it a little bit. So generally in this DGA agreement, the contribution rate is going up from the prior contribution rate of 11.25% to 13.5% in 2026, and then to 14% in 2027, right? So it's a very significant jump. And by the end of this contract, the total contribution for both health, which we just discussed, but also there's contribution to the pension plan, is going up to 22.75%. So it's a very substantial increase from the current 20%. Then there are some contribution caps that are going up as well. The most notable one is for motion pictures. So under the last contract, the cap of contributions was on compensation of up to $300,000. That took a big jump right now with the current contract up to $520,000. And then it's going up again to $600,000 in 2027 and to $650,000 in 2028. So especially in the motion picture space, you're increasing your percentage contribution, but also the cap on that contribution is substantially higher. There are also cap increases for pilots and for TV movies. Ryan, was there anything you wanted to add for that?
Yeah, I think one important note to add is that there are some strings attached to these increases, whereby the AMPTP essentially said, okay, we'll agree to these increases provided that certain changes are made to your health plan in order to, shore up things on the DGA side, presumably similar to what we've seen with the other guilds, whereby the eligibility thresholds are increasing. And so the DGA has advised the AMPTP of certain modifications that they've proposed, and those modifications need to be adopted by the end of this year. And if they're not, then all of these increases revert back to what they were going into the negotiation. So that's one caveat, though we surely expect that those modifications will be made.
Yeah, and I don't want to spend too much time on this, but to just sort of underscore how important the health plans were in this round of bargaining, there's also a diversion right where the DGA can divert other compensation back to the health plan. So there's a way to sort of kick even more money into the health plan. It shows that this was really one of the main financial issues in this bargaining cycle.
It's been a huge issue for all the guilds in this cycle, of course. And so from the bottom line from the studio side is that more of the fees that they're paying to the talent are going to be subject to these contributions, and the contribution rates are going up as well. But to your point, Ryan, it's sort of everybody is going to have to pitch in so they can move forward in the same direction. All right, guys, fantastic. So the next topic, everyone's favorite subject, AI. The last agreement was the first time this was addressed, and to some degree, the guilds, the DGA, they're really sort of creating this as they go as the technology changes and the landscape changes. Can you create some context for us here in terms of what was agreed the last time and what's new this cycle? Brian, maybe I can throw it over to you for this one.
Sure thing. So I like to think of what the DGA did last cycle in three different buckets: creative rights, which are paramount for directors, job duties, and also AI training. And while the DGA's regulations weren't extensive, like, say, SAG-AFTRA's, they did pack a bit of a punch. And so in 2023, on creative rights, the rule was that the producer must consult with the director before using AI on creative elements, which is quite broad and a bit vague. And that has now been solidified and also expanded. And so for creative rights now, a couple points to focus on. First is that any AI generated footage that's added to a picture is considered footage under the DGA agreement, which is going to provide directors with some enhanced rights and protections during the editing process. And further to that editing power that the directors have, the directors now have the right to request that the producer notify them if editing is going to be done using generative AI to the extent it's known at the time. And so that's the creative rights bucket, some modest expansions there. Then when you think about job duties, under the 2023 agreement, it was a similarly broad standard of the producer cannot assign customary director duties to generative AI. Now the rule is, in addition to that rule, the producer, again, upon the request of the director, must inform the director of uses of generative AI that will be required by the producer in the director's duties, to the extent known at the time. Again, to me, this one's very interesting because it raises the prospect of, at the deal stage, when an offer is being made and a deal is being negotiated, is the director going to, or perhaps even able to, under the current terms, put the burden on a producer to then answer this question of whether they're going to be required to use generative AI, and would a director use that in making a decision about whether to move forward? So one interesting thing there. Finally, training, AI training. This was quite loose in the 2023 agreement. It was really a meet and discuss obligation, as this continued to develop. Now you're seeing the DGA take the same approach as its sister guilds in terms of a more strict formal requirement to, if a director's results and proceeds are being licensed under a paid license to an unaffiliated third party, to train a publicly facing AI system for the purpose of creating motion pictures. Then, upon the request of the guild, the producer must meet with the guild to discuss that license and potentially remuneration as well. So I put a lot of emphasis on all of the caveats that are along the way. The most important one to understand is that this does not prohibit or require meeting and conferring if the producer is only using the pictures to train its own internal AI tool. So this is really about licensing out to unaffiliated third parties. So there are quite a few conditions that must be met in order for these obligations to apply to the producer. And it really reflects producers saying, this is our IP and we should be able to generally do what we want with it. However, the guild then says, if you're licensing it out, then it starts to become in our domain, akin to how we regulate residuals and so on and so forth. But perhaps the most interesting thing here with AI was a slight embrace of AI. And Dan, I want to kick it over to you to speak a little bit about that.
Yeah, I mean, we've talked about this, Ryan. I think it's really interesting. some people in Hollywood have taken a very defensive approach or protective approach to AI. The DGA agreements creates a training program, right? Effectively funded by the employers that's designed to, well, sorry, I want to be more specific. It's a GAI or generative AI skills enhancement program, right? Which effectively is designed to allow DGA members to enhance their skills to be able to use AI. And I think this is an interesting turn. I think it makes sense for directors, especially when they're trying to have AI not diminish their creative rights, right? If you effectively want to have a modicum of control over AI, you have to know how to use it. And so this is basically a skills training program, which is something the guilds generally tend to do well. We know that there's a very successful writer, executive producer boot camp for TV that WGA runs. So this is a GAI training program that the DGA is going to run to help train their members to become more familiar with the tools at their disposal, and then hopefully facilitates their input when AI comes up in their work duties.
Yeah, it's a fascinating development, and it really, to your point, Dan, it goes to, I think, two of the things that we've been talking about in each of these negotiation cycles across the guilds, which is these concepts of compensation and control. And you talked about the control element of this in terms of being able to take control of these tools to use them in their work. Ryan, you talked about the control element of this when it comes to creative rights and being in charge of what these cuts and the editing are going to look like. And I think this disclosure around licensing to third parties is a first step along the way to talking about compensation for such usages. So the environment continues to develop here. Let's get into another area which we kind of refer to generally as director recognition. Folks in the industry know how important it is for artists, for their contributions to be acknowledged both personally and as well as for their career trajectory. Dan, maybe you can talk a little bit about the changes that have been agreed in this area.
Yeah. And so I just want to make a couple of quick points for orientation purposes, right? There's generally been a distinction in the industry between film, what used to be theatrical film, but now film for theaters and streaming, and for episodic TV, right? TV may be an outdated term, but episodic series for TV and streaming, right? There are two categories of sort of directors, one who does shorter form, one who does longer form, although a lot of people go back and forth. But these regulations are largely focused on episodic, what used to be called episodic television, episodic series. So there are a couple of new rules that are intended, I believe, to enhance the profile of episodic directors. The first and perhaps the most notable is a new credit, pilot directed by. So if a director produces a pilot, or for those who really work in this area, it's not only a pilot, but a first episode of a series or an episode 101. Whether it's a traditional pilot or a 101, there for new series under the new agreement, there's going to be a pilot directed by credit, right? So that's a change. There's also an initiative for employers that have affiliated streaming services to identify the episodic directors on the streaming services menu and tiles, so that basically when you're browsing your streaming service and looking for different titles, that the director's name pops up and is sort of part of the frontline or headline credits. Another somewhat related rule that came up is increased press obligations with respect to episodic directors. So there's one rule that requires the inclusion of the director in a series press release, right? You effectively need to identify the director when you're doing press for a new series. And if there is a series website, you now have to include a director biography on the series website. And finally, hopefully people were doing this before, but if you have somebody who directed your pilot or episode 101, they're supposed to be invited to the premiere, or now they're required to be invited to the premiere. But I think sort of as a package, right, these are all designed to enhance the profile and sort of raise the publicity that's affiliated with directing, certainly episodic TV, and particularly a pilot or first episode of an episodic series.
Yeah, there's so much more action in the television world, of course, than there was some years ago. And so many of these film directors are directing TV now as well. And for folks who work in the area, they understand that directing a pilot really is a huge contribution to the creatively what the series is going to look like. You're effectively creating the tone and the mood and the pacing for the entire series, and so that's reflected in the fees as well, of course. Guys, before we move on, I thought maybe while we're still talking about AI, there was an interesting question here in the chat about the disclosure and meet and confer obligations when GAI is being used in the editing process. Are there any concerns, from the talent side about those sort of those requirements potentially being used to circumvent or minimize sort of the no cutting behind creative rights approach that directors want to make sure is being followed?
Ryan, you want to take it
Yeah.
or?
Yeah, absolutely. I think there is concern about that, and that's why you're seeing it addressed in this way. I mean, specifically that definition of footage point that I emphasized. I think that is meant and designed to ensure that footage, not just a picture, or still, or some really minor thing that's added, but or an edit maybe that's done through traditional, artificial intelligence means, but footage that's added. That is something that the directors are concerned about and something that they want to be involved with and consulted on and have the opportunity to work with. So, yes, I do think that's a concern and what the DGA was seeking to address here.
Yeah, and the agreements, including DGA agreement, acknowledges that even before 2023, there was use of AI in post-production for things like color correction or fixing sound or something like that. I think a lot of these regulations are sort of pointed towards the newer and more innovative uses of generative AI, some of which probably haven't even emerged yet, to sort of provide some oversight. And I'm going to separate it out. There are obviously SAG rules as well about, manipulating people's appearances or creating artificial characters, that stuff. That's a different topic for a different day that probably Ryan covered at least in part. So, but yes, I think there's a lot of concern. People are trying to prognosticate forward how this is going to continue to develop. And so they're trying to set up guardrails around it as it progresses.
And I think that's what it leads potentially into another interesting question that's come up in the Q&A, which is it seems like there's a tension between the 4-year term of the new agreement at the time when there's rapid technological change in the area of AI deployment and all these productions as well. What you're thinking on why the Guild agreed to this or how they're navigating this tension? Is it really about sort of focusing on the pension plans? Is it that there's going to be an understanding or a belief that there'll be some interim agreements that could be possible in these areas? How do you deal with that?
Well, I mean, just specifically to the AI portion, right? That's really very expressly acknowledged in the agreements that this is a constantly changing area of technology. And I think that's why it's structured to a degree, at least, as we're going to meet and confer, we're going to talk, right? And we're going to have an ongoing conversation about how AI is developing. It's very difficult to set up concrete rules for something that's changing so quickly, right? Lawyers know generally, right? The law has a difficult time catching up with technology. This is an attempt to sort of, I think, largely foster a dialogue about it and have certain guardrails as the technology is emerging.
Great, great. Okay, so let's jump ahead here and let's sort of get into some of the nitty-gritty with the time that we have left. Let's talk about some of the specific rule changes in TV and film that our practitioners won't want to miss. These are production-focused issues that are going to be helpful for BA folks and people who are working with UPMs. Ryan, why don't you get into it for us on the TV side?
Yeah, so on the TV side, perhaps the biggest new rule is the affiliated hire provisions. And so this is a new rule that essentially limits the number of episodes in a television season on which someone can be engaged as a director if they're also being engaged in another capacity, such as an actor or a writer. Now, there are some exclusions to this rule. So, an affiliated hire means that someone who's a director and also doing something else. Although, if they're a producer or if they're the showrunner, then generally they're excluded from these rules. But the intent here is to ensure that career directors and people who have extensive experience directing are the ones being put to work in directing episodes. And the rule itself is that if it's 7 or fewer episodes in a season, then no more than one episode can be assigned to an affiliated hire. And if 8 or more episodes in a season, no more than 2 episodes can be assigned to affiliated hire. So think here about actors or writers other than the showrunner who perhaps negotiate to direct an episode as part of their deal. Producers need to be more careful now about managing the number of episodes that they're allowing those individuals to direct on.
Hey, Ryan, can I just step in with one additional point? I know there's a lot to cover in affiliated hires, but this specifically applies to people who haven't directed at least 8 episodes of television, right? So there are some actors out there who are also longtime television directors, and those people are sort of exempt for those rules. It's sort of for the less experienced directors who also happen to be working on the series in another capacity.
That's right, and thanks for making that clarification, Dan. There's some other fine print here with this rule as well. It's a pretty extensive rule, like the pilot first episode does not count against the cap, things like that. So there's definitely some more to be aware of here, but that's the broad strokes of the rule. In terms of prep and shooting time, note, before I move on from that rule, note it does take effect in October of this year. So there is a little bit of a delay there. In terms of prep and shooting time, July 2027, network prime time and high budget SVOD is going to get an additional prep day. So you're going from 7 to 8 days there, which together with the 9 shoot days will be 17 days in total. Of course, that extra prep day is going to come at an added cost, but that is part of the increased guaranteed period. For shoots, the producers are going to be entitled to 1 non-consecutive shoot day now. So the idea here is that directors are generally required to conduct prep and shoot consecutively with intervening non-work time to be paid up to a cap number of days. Now producers are going to be able to engage a director to do 1 shoot day non-consecutively without triggering that paid intervening time. Of course, that shoot day is going to be paid itself, and it doesn't count towards your guaranteed obligations, but it does help you on the consecutive employment issue. Last thing I'll mention here on TV is just a point on excerpts. There has been a significant increase in the amount of fees owed when footage that's shot for 1 episode but not used in that episode. So we're talking about cutting room on the floor footage is used in a separate episode. So that does require a payment. And I think the most important thing for people on the call to be aware of is footage that's shot for 1 episode, even if it's not used in that episode, cannot be freely used in other episodes. That's considered an excerpt and payable under the guilds. And now the payment for that type of use in particular is going to go up significantly. I'll kick it over to Dan.
I just want to highlight, because that's something that comes up a lot in production, right? If you're moving footage between episodes, right? If you're, in post or whatever, or, the writer's room decides, let's move this story arc from 1 episode to another, there's a new increased clip fee for that.
Absolutely.
Dan, why don't you pick it up? Why don't you pick it up for film for us, Dan? What are the top level things to be aware of?
Yeah, there's just one other point I wanted to make quickly, which is there's a new 1 program director rule for live variety specials. This was an issue because some people were trying to get vanity credits for these variety specials, these sort of event productions. Now there's a 1 program director credit based on the person who controls the live transmission. So you can't just throw someone's name in to be a director. With respect to film, in the last agreement, there was this addition of a soft pre-production weekly payment, right, which was basically a $5,000 a week rate with a cap of $50,000. It's now going up to $60,000. And there's a sort of analogous payment that's been added in this cycle for extended post. It's very specific. If it's a budget of $40 million or more, you earn less than 150% of scale, then you get paid $5,000 per week If post extends more than 9 months after the director's cut, that's subject to a cap of $50,000. It goes up to $60,000 in 2027. But the takeaway is that for film, you now have to be somewhat concerned about soft pre-production, which is when other crew members are brought on in addition to the director, as well as keeping featured directors who earn a certain salary on for a very long post period.
Great, and guys, we're bumping up at half an hour here, but I thought maybe you could give us the headlines here as well, Dan, on just sort of some of the big picture residuals things for folks to be conscious of moving forward, the changes.
Yeah, I mean, there are a lot of detailed residuals provisions, but generally speaking, high budget SVOD residuals are going up. There are 2.5% increases, and there are all sorts of increases to foreign subscriber tiers, foreign free television residuals. There are a lot of details in this that we can't cover in the time that's left, but I think Ryan may agree with me. This is one where, talk to your in-house labor relations department if you have one, talk to your outside labor council if you have one, or talk to your payroll service that should be tracking these changes to high budget SVOD residuals.
It's a great roundup. Ryan, do you have anything you want to add to our conversation before we call it a day today?
Yeah, I'd say one of my biggest takeaways here is from this new agreement is that the DGA really wants to ensure that its members are the ones who are working. As I look at these rules, when it comes to the affiliated hire provisions that we discussed, when it comes to AI, and then there was some other points they made about the geographic scope and things going abroad, and there was an emphasis put on producers not inquiring about union membership when they're hiring directors abroad for foreign TV productions. So I think what I took away from a lot of this is that the DGA, of course, wants to get everyone back to work, but also wants to ensure that its members are the ones who are doing the work.
Great. Well, thank you both so much for your expertise today and for running through all these details with us. We know there's a lot of work in parsing these MOAs and picking up on all the new changes. And I want to thank you both for your contributions, not just today, but to the previous panels we've done as well. So on behalf of the Beverly Hills Bar and the Entertainment Law section, thank you very much.
All right. Thank you.
Thank you, David. Appreciate the time.